So let me get this up. So Jeremy Hales served your dad, who's also Richard Luthmann, in August. Earlier this month, I don't remember how recent, he filed whatever you're supposed to file, claiming that you had been served.
September 25th, he filed an affidavit of service.
An affidavit of service. And then he filed this thing, and he's arguing, and look, this is a YouTube video called The Unknown by Dick and Volpe. I have no videos that I call Dick and Volpe, though they did get the right video. Now, I asked you about this in the video they're referring to. I said, well, by going online, aren't you acknowledging service? So his attorney, his name is Randy Shockett, seems to think you are. How is he wrong?
I have not received service. Okay, I have not. They have not shown an affidavit of service where a process server has effectuated service upon me that's compliant with the law of the state of Florida. And that is a jurisdictionally achieving constitutional level event that has to happen. Okay, the law of the 11th.
But if they served your dad and they're saying you were served, isn't that
no,
one and the same?
They served another guy named Richard Luthmann. So they're saying, and the affidavits are not even specific enough to pass muster for him, in the sense that they haven't defined Richard Luthmann Sr. versus Richard Luthmann Jr. They have not amended their complaint. What's going to get them is they had to have amended their complaint with specificity when they realized that there was a Richard Luthmann Sr. and a Richard Luthmann Jr., and they didn't do that. They're going to get bit in the ass by the court, and this whole thing's going to get potentially thrown out because if they have served my dad, and they filed a motion now to confirm the service. My dad's going to answer that. He's going to respond to that motion. But my dad has also been seriously injured. And he's a serious personal injury now because of all the abusive process and the intentional infliction of emotional distress these people cause. He's caused him to have seriously physical injury.
He was playing
because of this, and he broke his 7th vertebrae. And now he's going to sue them for $10 million. So what's going to happen now is he's going to come back in this case and sue them, Jeremy Hales and Randy Shockett and his law firm and Deborah Turner Ingalls and every one of them for $10 million personal injury that was caused by their abusive process and their intentional infliction of emotional distress and their elder abuse. This is going to be a terrible thing that they did. And that's in addition to the federal government and the Florida authorities investigating Jeremy Hales criminally for his elder abuse as a paid agitator. This is terrible, terrible thing that these people are doing.
What's wrong with the argument that is on the screen? Why they also say that you in separate lawsuits you have addresses that aren't yours, that when their process server went to the address either no one was there or someone answered that wasn't you, so you are avoiding service by putting in addresses that aren't real. How do you respond to that?
I have the law in front of me. I will read this law into the record of our show so that anybody who wants to know is what it is. The 11th Circuit has held that actual notice of a lawsuit is insufficient to confer service. Quote, a defendant's actual notice is not sufficient to cure defectively executed service. That's called Albra versus Avdan, Inc. 490 Federal 3rd, 826. That's the 11th Circuit from 2007. That's clear law. Additionally, Rule 4, which governs service, Rule 4 of the federal rules of civil procedure says strict compliance is required. Quote, service of process is a jurisdictional requirement. A court lacks jurisdiction over the person of a defendant when the service of process is not perfected. That's Pardazzi versus Coleman Medical Center, 896, Federal 2nd, 1313, 11th Circuit, 1990. Now, finally, the most important one for my case, Michael. A parent's house is not effective service on somebody else. Okay? Service at a parent's residence is not sufficient if the defendant does not reside there. That's Morris versus Herron, 52 Federal 3rd, 947, 11th Circuit, 1995. And what these cases say is that due process requires more than somebody potentially knowing about something. It requires the actual act of service. It is the law.
All right, but let's address, I got it. Let's address first. He says the above demonstrates, and he, in a meticulous manner, suggests that you were evading service by saying that in one lawsuit, you listed one address. They went to that address. The person who answered said they weren't you. In another lawsuit, you listed a second address. They went to that address multiple times. No one ever answered. The above demonstrates that multiple prior attempts to serve Luthmann were unsuccessful because Luthmann has been actively evading service of process. And then they do number one. Even in the absence of good cause, a district court has the discretion to extend the time of service of process. And they list some cases as stated by this court. The apparent efforts by defendants to evade service would likely justify the court exercising its discretion. So they are arguing that they should have had an extension because they served on October 4th, which is past the deadline. Then they said, on October 4, 2025, plaintiffs effectuated substitute service by leaving a copy of the summons and complaint at defendant's dwelling with his stepmother. Do you still live with your dad?
I've never lived with my dad. I've never lived at that address. I've never lived in the Jacksonville area up in Ponte Vedra. Now, here's the big point, Michael, and this is the actual beautiful point about this. My witness, for me, if they want to force this issue, is none other than United States Magistrate Judge Nicholas Mizell. In my case against Dinesh Nishirvan, Luthmann v. Nishirvan, in the 11th Circuit in the Fort Myers Division of the Middle District of Florida, I have had 2 open and notorious hearings that were scheduled by order of the judge. Okay. Now, Jeremy Hales and Shockett cite that case. They cite that case in this to bolster their argument. If they look at the court docket on that sheet, on July 17th and again on September 10th, I was at the courthouse for a hearing, open and notorious, and I would have accepted service on both those times. And I spoke to the judge on both those times. They could have been in the courtroom and they could have handed me the papers and there would have been no issue. The fact is, we have the Castle Doctrine in Florida, and it's a lot safer for somebody to get served at a courthouse where people are acting in a genteel way. They don't have to worry that somebody's coming for them. And actually, that's probably something that is preferable, that it's done at the courthouse. And there were other times when I was at the courthouse where they talked about me potentially being at the courthouse and conferencing people at the courthouse. I would have accepted service, and I will accept service any day at the courthouse. The problem is, their time to serve is run, and they were not due diligent. In order to get due diligence, in order to get an extension, they have to show due diligence. And by citing what they cited, they shot themselves in the foot. The court record in Luthmann v. Nishirvan is clear. Luthmann was at the courthouse at least twice, and everybody knew it for weeks. So they have not done their due diligence because it collapses the entire system of justice that this person is not locatable when he was at the courthouse twice during the
right. Now I read this before, but let's read it again and you answer this part. Luthmann has denied living in his parents' home. It's one parent and I guess a step parent. Despite this denial, Luthmann has confirmed actual receipt of the court documents served on his parents on October 4, 2025. Luthmann did this by posting about the summons and complaints served on his parents on August 4, 2025 by referring to, quote, 100 pages of document in a YouTube video titled Unknown. It wasn't titled that, but he does provide link to the video. You were not holding the lawsuit. Your dad was holding the lawsuit, but isn't it fair to say you acknowledged the lawsuit in that video?
No, because first thing is, and you look in that actual paragraph, they misspelled my name. It's not Luthmann, it's Lutham. And so I think they intentionally did that to try not to make a misrepresentation or commit perjury. Because by saying that I actually have actual knowledge just by posting about a summons means that, Michael, you have actual knowledge because my father showed the summons to both of us on the screen, and it looked like it was over 100 pages, and he told us it was over 100 pages. You have the same level of knowledge of that lawsuit that I do on that. So it shows that you have actual knowledge of the lawsuit too. Michael, can you be now served with those papers? Can you run to the court and amend those papers and say, oh, Michael Volpe now because he has actual knowledge that there's a lawsuit? It's crazy. You need the jurisdictionally compliant and the constitutional level action that's required by the law. That's why. And it also has a First Amendment issue, a free press issue. It says us as reporters can't report about things because we might be mentioned inside the lawsuit. That's crazy.